Hello everyone, I am Aniruddha Tiwari, Director and Chief Mentor of Dronacharya Civil Services Academy. Welcome to our YouTube channel where we provide resources and guidance to those who want to become civil servants. In last lecture, we learned about the President of India, how a president is elected, his qualification, a term of office, impeachment process. Now, we start today, power of the presidents. Power of the president. According to Article 60, as a head of the state, the primary duty of the president is to preserve, protect, and defend the constitution and the law. He enjoys executive, legislative, judicial, diplomatic, and military powers. He has been granted the responsibility and authority to protect of the constitution. First, we discuss executive power of the president. For a better understanding, the power of the president can be categorized into appointment and administrative powers. Appointing powers and duties of the president. He has the power and responsibility to appoint the Prime Minister of India and his Council of Ministers on the recommendation of the Prime Minister. The President of India appoints the Chief Justice of India. He appoints the Governor and has the power of dismiss him if he has violated the Constitution in their acts. He appoints various constitutional dignities like Comptroller and Editor General, Chief Election Commissioner, Chairman and Member of the Union Public Service Commission. He appoints Attorney General and determines his remuneration. Account General holds office during the pleasure of the President. Administrative powers and duties of the President. The executive power of the Union are vested with the President of India mentioned in Article 52. The Parliament can grant additional powers to the President if it deems fit, and these powers can be further delegated by the President to state governors. He can make rules for the convenient transactions of the business of the Union governments under Article 77. He can seek any information from the Prime Ministers regarding the administrative affairs and legislative proposals of the Union. He administers the Union territory by the administrators appointed by him. He can constitute an interstate council for cooperation between the center and the state. The extent of the President's executive power. Important line. The Supreme Court in Ram Jawai Kapoor versus the state of Punjab 1955 remarked the executive power is not confined to the administration of the laws already enacted. It also includes the determination of governmental policy, initiation of legislation, maintenance of law and order, promotion of social and economic welfare, foreign policy, etc. Next is legislative power of the President. The President has the power to summon, prorogue, or dissolve the Lok Sabha. A bill passed by both the House of Parliament can become a law only if it has received assent from the President, subject to limitations. The President of India has the power of nominate 12 members to the Rajya Sabha who have made extraordinary accomplishments in the fields of science, art, literature, and social service. The President has the power to send a bill back to the Parliament unless it is a money bill or a constitutional amendment bill. Under Article 108, the President can call a joint sitting of both houses. He does not preside joint sitting. He addresses the first session of Parliament after the general election and the first session each year. His prior permission is required for the introduction of subtypes of bills like a bill involving the reorganization of states and territories. He can disqualify the member of parliament on the recommendation of the Election Commission of India. He lays the reports of CAC, UPSC, Finance Commission and other before of the parliament. He can promulgate ordinances when parliament is not in session. Ordinance making power of the president. Ordinance making power of the president. Under Article 123, the Constitution, the President can under Article 123 of the Constitution, the President can promulgate ordinances during the recess of the Parliament. When the Parliament is not in session, the ordinances are promulgated in situations that need immediate action from the government. The ordinance making power is the most important legislative power of the President. The ordinance making power of the President is not a discretionary power. He can promulgate or withdraw an ordinance only on the advice of Council of Ministers headed by the Prime Ministers. Important features on ordinance making power. Ordinances have the same power as an act of parliament. They are temporary in nature. They can be retrospective. It means they may come into force from back date, can modify or repeal any act of the parliament or an ordinance, can alter and amend tax laws, cannot be issued to amend the constitution. The President can withdraw an ordinance at any time. No connection with the national emergency under Article 352. The President can issue an ordinance even when there is no national emergency. Next is limitations to the ordinance making power. President's ordinance making power is subjected to the some limitations, like is firstly not a parallel power of legislation. Ordinances can be promulgated only when both the House of Parliament are not in session or when either of the two houses of Parliament is not in session. An ordinance that is put into place when both houses are in session is void in law. In DC Wadhwa versus State of Bihar, case 1987, the Supreme Court ruled that the ordinance making power should be used in exceptional circumstances by the executive. An ordinance can be issued only on those subjects on which Parliament can make laws. President's power to roll out an ordinance is judiciable and its judicial review is possible on the ground of malefied. In the Cooper case, 1970, the Supreme Court held that the decision of the President to promulgate an ordinance can be questioned in the court of law on ground of malefied. The ordinances cannot be promulgated to bypass the debate and discussion in the legislature. The President's satisfaction and decision are promulgated. An ordinance was made conclusive and joint judicial review under the 38th Constitutional Amendment Act of 1975. However, this provision was deleted by the 44th Constitutional Amendment Act of 1978. Parliamentary approval during the session. Important line. An ordinance has a maximum life valid for 6 months, after which it needs the approval of Parliament within 6 weeks of resembling, or it shall case to operate. Acts that were done and finished under the ordinance before the expired continue to work. According to the rules of Lok Sabha, whenever a bill seeking to replace an ordinance is introduced in the House, a statement stating the circumstances that had necessitated the ordinance has to be placed before the House. In line with fundamental rights, the ordinance must not abridge the fundamental rights. Next is veto power of the President. Article 111. Article 111 of the Constitution of India says that the President has the power to veto bills as soon as a bill has been passed by both the houses of Parliament. It will be sent to the President. A bill becomes act after the assent of the President. The President does not enjoy veto power in case of constitutional amendment bills. So, he must give his assent to the bill. The 24th Constitutional Amendment Act of 1971 made it obligatory for the President to give his assent to the Constitutional Amendment Bill. When a bill is presented to the President for his assent, he has three options. First option is give assent. Second option is withhold assent. Third option is return the bill for reconsideration of the Parliament, exceptionally money bills. However, if the bill is again passed by the Parliament with or without and again presented to the President must give his assent. Next question is, what is the purpose of giving veto power to the President? Important questions. There are two reasons for which veto power has been given to the President. First is to prevent legislation which are unconstitutional. Second is to prevent hasty and ill-considered legislation by the Parliament. The President of India enjoys three types of vetoes: absolute veto, suspensive veto, and pocket veto. The Indian President does not have a qualified veto. First, absolute veto. It is the power of the President to withhold his assent to be a bill passed by the Parliament. In this case, the bill does not become an act. Conditions under which absolute veto is used with respect to private members' bill, with respect to government bills, when the cabinet resigns and the new cabinet advises the President not to give assent to such bills. For example, in 1954, an absolute veto was exercised by Dr. Rajendra Prasad as a President when he withheld the assent for the PEPSU appropriation bill. In 1991, an absolute veto was exercised by the President R. Venkat Raman when he withheld his assent to the salary allowances and pension of the members of Parliament bill. And next is suspensive veto. The President of India uses a suspensive veto by returning the bill to the parliament for its reconsideration. The president cannot use any of his veto powers when parliament rescinds the bill with or without any amendments. This means that the suspensive veto of the president can be overridden by the repassage of the bill by the parliament. The president does not possess this veto in case of money bills. He can either give or withhold his assent but cannot send it for reconsideration. Generally, the president gives the assent to money bills as they are introduced in parliament with his prior permission. Next is pocket veto. Article 111 of the Indian Constitution does not prescribe any time limit for the president to give his assent to a bill passed by the parliament. The president can practically postpone action on a bill for an indefinite time and not return it to parliament. This is known as the pocket veto. Pocket veto is a situational discretionary power of the president. For example, in year 1986, President Gyani Jail Singh exercised pocket veto with respect to Indian Post Office Amendment Bill. Presidential veto power over state legislations. A bill passed by the state legislature is placed before the governor of the state for his assent. In this case, of the governor has four options under Article 200. First is give his assent to the bill. Second is withhold his assent to the bill. Third is return the bill, exceptions money bill, for reconsideration by the state legislature. And fourth is reserve the bill for consideration of the president. When a bill is presented to the president for consideration, he has three options under Article 201. First option is give his assent to the bill. Second option is withhold his assent to the bill. Third option is direct the governor to return the bill, exceptions money bill, for reconsideration of the state legislature. If the bill is passed again by the state legislature with or without amendments and again presented before the president for his assent, the president is not bound to give his assent. Also, the constitution does not mention any time limit within which the president has to take a decision on the state bills. Thus, the president can use his pocket veto power with respect to state legislations. Next is military power. Military power of the president. The President of India is the Commander-in-Chief of all the Indian Armed Forces. He appoints the chiefs of all armed forces. The President has the power to declare war or conclude peace with any country on the advice of a council of ministers headed by the Prime Ministers. Next is diplomatic powers. All treaties with any foreign countries are signed in the name of the President of India. He appoints the ambassador and receives the credential of the foreign diplomatic representatives. Next is financial powers. Money bills can be introduced in the parliament only after the prior recommendation of the president. He can make advance out of the contingency fund of India to meet any unforeseen expenditure. He laid down annual financial statement, means union budget, before parliament in each financial year. He constitutes a finance commission every 5 years for recommending distribution of revenues between the center and the state. Next is judicial power. Next is judicial powers of the president. He can seek advice from the Supreme Court on any question of law or fact. Any such advice given by the Supreme Court is not binding on the president. He can grant pardons, remit, commute, and respite the sentences of the persons who are convicted under any union law court martial, and death sentences. Next is emergency powers. This is the very important powers as a point of main exam. The protect the state sovereignty, unity, integrity, and security, part 18, Article 352 to 360 of the Indian Constitution provides emergency provisions. The President can proclaim three types of emergency under Article 352, 356, and 360. Article 352, National Emergency. Article 356, Presidential Rule in States. And Article 360 in Financial Emergency. Next is pardoning power of the President. Pardoning power of the President. A person who has been convicted of a crime under the Indian Penal Code 1860 and sentenced to death may have his sentence suspended, remitted, or commuted by the President of India under Article 72 of the Indian Constitution. The President has the power to grant pardons if the punishment of the crime is an offense against Union law granted by the military code. The punishment is that of the death. Rationale behind providing pardoning powers to the President. First is to correct any judicial errors in the operation of law. Secondly, to afford relief from the sentence which the President regards as a unduly harsh. Next, pardons, types of pardons. First is when the President grants a pardon, the sentences, punishment, and disqualifications meted out the offender are nullified. Second pardon is respite. A lesser sentence is granted in place of the original one when the President exercises his respite. And third, pardoning powers. The President may exercise this authority, for example, if a convict has a physical disability or if a female offender is pregnant. Third pardoning is reprieve. As soon as the President uses the pardoning power of the reprieve, he temporarily suspends the execution of a sentence, particularly the death penalty. As a result, the inmate has more time to petition for clemency or commutation of sentence. And next pardoning power is remit. In a remit pardon, the President acts to reduce the sentence's length, but it retains its original character. For example, a sentence of 2 years of strict imprisonment may be reduced to 1 year of strict imprisonment, but the punishment is still strict. Nextly, the difference between the pardoning power of the President and that of the Governor. Very important. By Article 161 of the Constitution of India, the Governor has the right to pardon. However, there are two major differences between the pardoning power of the President and that of the Governor of State. First difference is pardoning power of the President can pardon sentences inflicted by the court martial, but the Governor cannot pardon sentences inflicted by the court martial. Second, President can pardon death sentences, but Governor cannot pardon death sentences, can only suspend, remit, or commute or a death sentence. Next is, Supreme Court judgments on pardoning power of the President. Firstly, regarding judicial review. In the Ipru Sudhakar case, Supreme Court ruled that the judicial review of the pardoning power is possible to rule out any scope of arbitrariness. Second is regarding to discretionary power. In Maru Ram versus UI, Supreme Court ruled that the pardoning power of the President is to be exercised on the advice of the central government, and advice is binding on the President. Now, we discuss the very important point, constitutional positions of the President. This is the very important for many examinations. Under the Constitution of India, the President is the constitutional head of the Union government who exercises his constitutional powers and functions on the aid and advice of the Council of Ministers headed by the Prime Minister. Dr. Bhimrao Ambedkar commented that the President occupies the same position as the King under the English Constitution. According to him, the President is the head of the state but not of the executive. He represents the nation but does not rule the nation. He is the symbol of the nation. The position of the President in administrations is that of a ceremonial device on the seal by which the nation's decisions are made known. Now, estimating constitutional positions of the President, Article 53 says that the executive power of the Union shall be vested in the President and shall be exercised by him either directly or through officers subordinates to him in accordance with his constitution. Article 74 says that there shall be a council of ministers with the prime ministers at the head to aid and advise the President, who shall in exercise of his functions act following such advice. Like his Article 75 says that the council of ministers shall be collectively responsible to the Lok Sabha. The 42nd Constitutional Amendment Act of 1976, enacted by the Indira Gandhi government, made the President bound to prime ministerial recommendations. In 1978, Morarji Desai government enacted the 44th Constitutional Amendment Act, which allowed the President to require the Council of Ministers to consider such advice either in general or in specific cases. However, according to the amendment, he shall act in accordance with the advice provided after reconsideration. This means that the reconsideration advice shall be binding upon the President. However, the President is not merely a rubber stamp and plays a significant role in Indian democracy. The significance of the Presidents can be understood from the method of election of President. While calculating the vote value of MLAs in presidential elections, the population of the state is a crucial factor. This implies that the people's presence in the process of electing the President is very much visible. It gives greater moral authority to the President. Ask questions to the Council of Ministers. The President can seek information on all matters of administration and legislation from the Council of Ministers headed by the Prime Ministers. The President can disagree with the decisions of the Cabinet and ask the Cabinet to reconsider them. Not a mouthpiece of the government, the President's oath contains two solemn promises. First, the President shall be preserve, protect and defend the Constitution. Second, the President shall devote himself or herself to the service and well-being of the people of India. A president who makes the above promises under oath to the people is not a mere mouthpiece of the government. Situational dictation. The president can act at his discretion, means without the advice of council of ministers under certain situations such as appointment of prime minister, when no party has a clear majority in Lok Sabha, or when the prime minister in office dies suddenly and there is no obvious successor. Secondly, dismissal of the council of minister when it cannot prove the confidence of the Lok Sabha. Thirdly, dissolution of the Lok Sabha if the council of minister has lost its majority. Presidential activism. It is when the president does not act according to the act and advice of the council of ministers. There have been a number of instances when the president has asserted his discretionary power. For example, India's first president Dr. Rajendra Prasad frequently disagreed with Prime Minister Pandit Jawaharlal Nehru and sometimes criticized the government in his public statements. In another instance, President Dr. K.R. Narayanan sent back the proposal to impose president's rule in Uttar Pradesh to the cabinet, asking the minister to reconsider it. To conclude that the Indian president is not just a rubber stamp, he is the protector and defender of the Indian constitution. Former President Ramaswamy Venkataraman had rightly observed, the office of the president is an emergency light. It comes on automatically when there is a crisis and goes off automatically when the crisis passes. Now, what type of questions generate civil services main examination? Let us consider a previous year mains questions. First, in instances of the presidents delaying commuting death sentences has come under public debate as a denial of justice. Should there be a time limit specified for the president to accept or reject such petitions? Analyze सिविल सर्विसेज मेन एग्जाम्स 2014 में क्वेश्चन पूछा गया था. सेकेंड क्वेश्चन, what are the major changes brought in the Arbitration and Conciliation Act 1996 through the recent ordinance promulgated by the president? How far will it improve India's dispute resolutions mechanism? Discuss. Civil Services Main Exam 2015. All the best. Thank you.